the way we're going to handle that aspect of your redirect, Mr. Sanders, is that if you want to ask Ms. Anderson a question or questions in connection with what you started to ask, and Mr. Rucker was able to follow up with one question about conversations Ms. Anderson has had with friends or neighbors or people she knows, however you want to phrase that, if those have been difficult for her, so might even phrase it however you want. But what you told me you were focused on is how that affects her state of mind. And I don't think, you may not get into, has it affected your business, has it affected your daughter, or something like that. I don't think that is. You need to come back to trying the case that's in front of the jury and not the case that the media may be trying to try out there. That's not what the jury's focused on, it's not what we're focused on. And so if you want to explore with Ms. Anderson, if what she has heard from her contacts, her friends, however you want to describe it, has affected her state of mind, made it somehow difficult for her to talk about this. I mean, what I heard you say throughout your comments is, of course I get to explore how it affects her state of mind here. And if you want to ask her if those discussions have, I guess I don't see where it goes from there, but you're welcome to explore how it has affected her state of mind. Is she upset? Is she mad? But it all has to relate to her credibility and whether she's had difficult conversations with her daughter. I don't see how that relates to her credibility. But maybe you can help me better understand that. If not, then...
I'm not, to be honest, I'm not exactly sure what you're allowing me to ask. To say, how has it affected you? I expect your answer to say, my daughter comes home crying from school because the people are saying to her, your mother, exaggerate a little bit, but your mother's, a prostitute. My husband, it's affected him.
Right, we're not going to elicit that testimony.
Well, that's how it's affected her, is because of...
Well, that's how it's affected her outside of court. What's relevant is her credibility here. And so if you...
How could I elicit that, The reason she is so adamant or animated in her responses here.
I haven't said she was, but
well, I'm
yes.
saying she is. When she says things like 1,000%, and she's so... It sounds overly strong. Why? Why are you talking like that? Because I'm dealing with the world outside where people are now accusing me of having sex with my patients, my clients, their customers. That's the way it's impacted her. And that has informed her testimony here. If I can't ask what the daughter and the husband, it's just such a vacuum at that point that all I can do is say, have you read the newspaper? What effect has the newspaper had on you? She might very well say, it's all a lie, I don't pay attention to it. That's not what's causing her to be so angry.
Okay, I'm following a little better now. What I'm saying is, if you can craft a question that elicits that she is in fact angry or hurt, she can pick the adjectives that describe her state, it's not mine or yours, because of the interactions she's had with folks outside court. You can elicit that. What you may not elicit are the specifics of who is telling her and what those folks are telling her. I think that's hearsay. I don't think Mr. Rucker opened that door, but I think it's appropriate for you to try to share with the jury that Ms. Anderson is upset about some of these interactions, and that might explain why she answered the way she answered. Personally, I don't know that it's all that remarkable that someone would be pretty adamant in responding to the question, did you have an adulterous relationship with someone else? I don't think you need to have your daughter coming home from school saying people are talking bad about you to have a pretty forceful response.
I disagree with you. If I were to say to you,
let's stop the dialogue on that front. I'm allowing you to ask her how she is feeling about what's happening outside of court as a result of the coverage. What I'm saying you can't get into is what it is that people are saying to her, or what specifically is happening outside of court.
I hope they'll give you a little bit of leeway to leave, to stay confined like
Sure.
that. And I will do that.
Okay. And you preserved your objection.
And I would like to, what I'm going to do tonight is ask the court reporter to just get me Mr. Rucker questions. And maybe revisit this in the morning. I may ask Ms. Anderson to be back here in the morning, just to play with, just to print out the one page, if she can find it fast enough. As to what Mr. Rucker asked right at the beginning of his direct examination, when he's done talking about sequestration specifically, did someone tell you not to watch the TV, or when did you meet with Mr. Samuel? Right after that, I'd like to see exactly the questions he asked. I thought it was much more door opening than you seem to suggest.
Okay. Well, you can work with Ms. Weaver after we're done today, and if that's something that she can accommodate, then you can always revisit. Okay. Anything, Mr. Rucker?
Just one thing, out of an abundance of caution with the court, maybe could we bring Ms. Anderson in and maybe just get a preview of the question and get the response to make sure that it is in limiting, because I don't want to have to stand up and object because there's a narrative that she goes into that goes into the areas.
I just assume let Mr. Samuel form the questions the way he wants to form them. I'll give him leeway to lead, but I will ask him to let Ms. Anderson know before she comes in here that she ought not to get into the specifics of these difficult situations that she's encountered as a result of the coverage. That'd be great. I won't bring the jurors in until you're back.
All rise for the jurors. All jurors are present and accounted for, Judge.
Thank you, Deputy Murphy. Everyone can be seated, please. We're going to turn now to redirect examination of Ms. Anderson. She remains under oath. Mr. Samuel?
Ms. Anderson, I want you to listen to my questions here, if you would. Have you heard about the press coverage of this case the last 6 weeks or so as it relates to you?
Yes.
And without going into any elaboration, how has it made you feel?
Humiliated and angry.
Mr. Rucker asked you with his friend, does the mannequin have a name?
Not yet.
The mannequin, about the polarities, and obviously the mannequin does not have clothes on. When you did the polarities, the touching of the shoulder,
Polarity rocking.
polarity rocking, was Mr. McIver fully clothed?
Yes, he was.
Shirt,
Yes.
pants, pajamas, whatever he's wearing,
Beanbag over his eyes.
and beanbags over his eyes. Have you ever worn Diane McIver's boots?
No.
And my last question, Ann Schwall was at the ranch on Saturday night?
Yes.
Ann Schwall is Austin's mother,
Yes.
biological mother, obviously.
Yes.
And you know her very well as well, correct?
Yes, I do.
Those are my questions.
Okay. Jurors, do you have any questions for Ms. Anderson? Pass them down to our savage juror.
Oh, I just read that. I was like, why do you call her that?
Don't worry.
You read there.
Great juror. more questions. We'll see if the lawyers have any follow-up. Tell the jurors, please, what the $5,000 advance or loan was for.
Can I look at them?
Yeah,
and answer?
please, you may look at them. Please do.
So I had a pool that was, as my real estate agent calls it, a Zika pool, because it was not properly working. And we were thinking about moving to Buckhead and listing our house on the market. And she wanted me to, in her words, get that done and fill in the pool so that it could be put on the market. So that was for the excavating, the 33 truckloads of dirt and all of that, which was actually starting that Monday morning. And my house being under construction with all that.
The days immediately following Ms. McIver's death, when you stayed at Mr. McIver's condominium and then drove him to the ranch, did you volunteer to do that, or did Mr. McIver ask you to help him with all those different things?
I volunteered, and he actually tried to get me to go home because he felt bad that I had not been with my husband. And I told him that if he sent me home, that my husband would come be with him and I would take care of my daughter, because I'm very close with Tex's family, sisters and brothers, and I was able to stay on the phone with them throughout the day and keep them updated. And I just felt like I was the best person to do that, to give them information on how he was doing, because they couldn't come themselves at that time.
Did Mr. McIver pay you for any of the time that you spent helping him out at the condominium, or getting him to the ranch and being there at the ranch with him?
No.
If you were watching over Mr. McIver while he was asleep those first few nights, when was it that you slept?
I really didn't. I think in grieving I was kind of pumped on adrenaline. I might sleep for a few minutes here and there, but being that I've done a lot of night nursing, I can kind of go into a half sleep or something like that, like a little bit of a doze, and still be able to wake up if the baby turns in the crib. So I just felt like little teeny kind of, not sleep, I wouldn't say I really slept that week, but little doze-offs here and there.
One more question about the $5,000. Did you ever sign a promissory note in connection with the money that Ms. McIver gave you?
No.
Do you know why the medication that you've described that was made available to Mr. McIver, that when you were dealing with it was only in an envelope? Do you know why it wasn't in the form of a prescription in a bottle as opposed to sitting in an envelope?
Rachel Stiles gave it to me in that so that we knew Austin was coming to spend the night, and there's a book, How to Raise a Gentleman, on her nightstand, and we just put the envelope inside the book because it wouldn't be a temptation for Austin. That way we wouldn't have to worry about having medication like that out.
Okay. Tell the jurors why you believe Ms. McIver's shoe size was 7.5.
Well, based on all the shoes, tennis shoes, boots, high heels, low heels that I saw, that just is what it looks like to me in a general size. And I've also touched her foot millions of times, and it just felt like that kind of size to me.
Did you and Ms. McIver have rubber boots with a similar style, pattern, or design there at the ranch?
She had multiple pair, and some of them were similar to the same patterns that I had and my daughter.
Do you still give Mr. McIver massages?
No, because I had not been able to see him.
Did Mr. McIver ever give you any of Ms. McIver's boots?
No.
Mr. Samuel, do you have any follow-up based on those questions?
No.
Mr. Roberts?
These are Judge, can I check the court? State's exhibits 398, 399.
398, yes. 399, yes, vote through Mr. Allers.
Yes. It states 398. Let me ask you, did you attend any of the, either the estate sale, the auction for Diane McIver's personal items?
No, I did not.
Okay. From your own personal recollection, do you recognize any of these shoes?
Not in particular.
Okay. And just for completeness, this is $3.99. How about any of these shoes?
No.
Okay. All right. Thank you. That's all my questions.
All right. Ms. Anderson, I appreciate your time. This is a difficult topic for you, but thanks for coming in.
Thank you.
You're free to go.
Thank you.
Ms. Clark-Paul?
Yes, Your Honor. The defense calls Mary Margaret Oliver.
Before we go any further, Mr. Samuel, we've discussed a few things outside the presence of the jury. I'm just reminding you of the rule of sequestration and how you want to proceed. About who's in the courtroom now and who's not. Sorry about that.
All right.
Let's swear the witness in.
Do you swear and affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, ma'am. If you will, have a seat. Get as close to the mic as you can. For the purposes of the court's record, please state and spell your name.
Mary Margaret Oliver, M-A-R-Y-M-A-R-G-A-R-E-T, Oliver, O-L-I-V-E-R.
Yeah, I'm sorry, may I just have one moment? I'm trying to find an exhibit. Okay. I'm sorry, I was trying
That's okay.
to find this before I could locate it. I found it. Okay. Miss Oliver, could you tell the jury what do you do for a living?
I have two jobs, but
Okay.
my primary job is I'm a lawyer in Decatur.
What kind of lawyer? What area of law do you practice?
I have done estate litigation and estate management as the county administrator for DeKalb County Probate Court for about 25 years. And in addition to that statutory appointed position, I also have a family law practice and a litigation family law practice.
And so your duties as estate, what was the first thing?
County administrator
County.
for DeKalb Probate Court.
All right, just sort of a couple sentences. What do you do in that role?
I think it's most like being a trustee for the probate court. When the probate judge has an estate or a conservatorship for an incapacitated adult or a child, they have the authority, the opportunity to appoint a professional neutral to serve as the administrator or the conservator. And I've done that by appointment from DeKalb County for about 25 years. I also have other estate privately retained matters in other counties.
Okay. And in that, since we're talking about probate in that role that you serve, do you work with wills and estates and that sort of thing?
Yes, I do.
Okay. And then your practice, what kind of practice did you say it was?
Well, I'm a private practitioner for estate litigation, estate drafting. Tends to come more in the area of conflict among estates. And then I'm a court-appointed administrator and conservator by courts, DeKalb County primarily, and I've done that for 25 years.
Okay. And in this particular case, what is your role with relation to the estate of Diane McIver?
I'm the administrator of the estate of Diane McIver, appointed by the Fulton County Probate Court Judge Pinky Toomer. I was appointed in July 2017.
All right. And how were you picked to be administrator of Ms. McIver's estate?
It was a little bit of a negotiation between the previous lawyers for the estate, Stan Smith and Kirk Watkins, and the district attorney's office. There was what I call a vetting process where I was interviewed by both teams. I was called initially by Kirk Watkins, who I went to high school with in the Emory area last spring, when he was active in the case representing the estate, and we began talking about the case. He was asking me some questions in my experience with other estates. I've administered probably 30 or so estates.
All right. And in your role as administrator for the estate, what are generally your kind of duties and responsibilities towards the estate?
For this estate or in general?
This estate in particular.
Well, I took over after Mr. McIver, who was the named executor in the estate documents. I took over for him, so he had done a great deal of work initially to gather the assets, make initial decisions about paying debts, and to evaluate what was owed by the estate and what the will directed him to do. So he had taken the estate up to a certain point. When I took over, I picked up where he left off and evaluated what was in the estate to be sold and proceeded to take those steps to sell the assets of the estate, which primarily, from my perspective, initially were 4 real properties, 4 pieces of property of the estate.
And so let me start with one piece of real property, and I'm going to, just so we can kind of follow along, put up a page from States 479. Let's start with the condominium at Buckhead. What did you do to evaluate the value of that piece of property?
A real estate agent had been retained prior to my appointment, and appraisals had been obtained prior to my prior to my appointment. So I was evaluating those documents, vetting the real estate agent who had a contract, a listing contract for a period of time, and was making some decisions about how best to, with the real estate agent's advice, how best to market it. And then you had the contents of the condominium, furniture, etc. There was also a wine collection. So I was trying to evaluate where we were in selling the contents with the condominium or selling separately, storing, making those decisions.
Okay. And for the contents of the condo, did you just assign a number to the furniture and the wine collection, or did you enlist the services of somebody else to come up with the value of those things?
I had a pretty good evaluation of the contents from some other entities that had looked at it and made a decision, preliminary decision about what the value of it might be. I've also had experience on my own of storing furniture and listing furniture, discounts, and knew the cost of selling condo contents. So I was in the process of making a decision, is it better to sell the contents with the condominium or separately? The wine collection was a separate entity, and I was evaluating ways I was legally allowed to sell wine and made some decisions about selling that.
Okay. And has the condominium been sold?
Yes.
All right. And did Mr. McIver have to agree to the sale of the condominium?
He did.
Okay. And why is that?
Because of the life estate.
All right. And the other real property is one of those other pieces of real property that was in the estate, the Clay building on Main Street in Conyers.
Clay Management owned the building, was titled in the name Clay Management in Conyers. It was a kind of a warehouse business building, and that also, when I took over the estate, was subject to a real estate contract and a listing that had a date on it. And we were able to sell that building to the only realistic buyer who was on the horizon for that property.
Okay. And then, how about the Grandview condo on Lakeside Drive? Has that been sold?
Yes, it has.
All right. And, so that's 3 pieces of real property. Am I missing one?
The 4th piece of real property is a lot on Lake Oconee. It's part of the Reynolds Plantation properties, and I believe it was purchased, Mrs. Diane McIver purchased it in her name for the opportunity for she and her husband to be members of the Reynolds Plantation and take advantage of their resources.
And has that one been sold?
It has not been sold, it's listed. It's a small lot on a cul-de-sac with several other listings.
It's a lot. Is there a house on it or any kind of structure?
There's no structure.
All right. And, so, and by the time you became involved in the estate, was there any billboards or properties that had billboards on them in Diane McIver's estate?
The billboards in her name, I believe, had been transferred as pursuant to the settlement around the DRS entity.
Okay. And now there's other assets in Miss McIver's estate beyond the real property, is that right?
Yes.
Okay. And for example, well, actually, before I do that, I forgot to ask you a question about, in your role as administrator for the estate, are you doing that for free, or are you charging for your time and work?
I'm being paid, and it was a negotiated fee with the lawyers previously representing the estate. It was part of the agreement from Mr. McIver, Mr. Tex McIver, and the estate lawyers and the DA, I think, may have been a part of reviewing that fee agreement. It's part of the negotiations.
And are you being paid, out of what account are your fees being paid?
The estate account.
All right. And is that allowable under the law?
Yes, it is.
Is that appropriate for somebody in your role to be paid out of funds of the estate?
Yes, it's actually a priority claim on the estate. Taxes, cost of administration, including attorney fees and accounting fees, and funeral expenses are by statute a priority claims on estates.
Can you give us a 1 or 2 sentence when you say priority claims on the estate? What does that mean?
It means it comes ahead of other entities looking for money.
Does it come ahead of any specific cash bequests that may be listed in the will?
It could, yes. In the estate of Diane McIver, based on the sale and the value of assets, there will be enough money to pay the bequest.
Well, that was going to be my next question. The specific cash bequests that are in Ms. McIver's will, have any of those been paid?
No.
All right. Is it your intention to pay them?
Yes, I've drafted some documents. The notes that are owed to the estate are part of the estate assets, and so a couple of the people who are receiving cash gifts also owe the estate some money, so there's some calculation going on there. But I have drafted some preliminary documents and I've informed a couple of the bequest beneficiaries that I'm going to make a partial distribution in the next couple of weeks.
Well, you have been administrator of, I don't know why I have such a hard time with that word, administrator of the estate. Has Mr. McIver been making interest payments on the $350,000 loan that he owes to Clay Management?
Yes.
All right. Has he paid that loan in full?
Yes, up through today, yes.
Well,
He's not paid the loan in full.
Yes.
I correct myself. He's paid the interest regularly. He has not paid the principal of the loan that's owed to the estate and is an asset of the estate.
okay. And, all right. Now, the other assets, I think you said there are other assets in Ms. McIver's estate beyond the real property, right?
Yes.
Okay. Does that include jewelry?
Yes.
All right. As part of your duties as administrator of the estate, did you take some steps to get a valuation of the jewelry that was part of her estate?
Yes, much of that was done by Mr. McIver or the people that were helping him. When I took the jewelry, most of it had current appraisals prepared for items of jewelry. There were some other appraisals that were old that had been obtained when the jewelry was purchased. So I was organizing that to see what had not been appraised and what needed to be appraised and what was left to be sold possibly.
And so all the jewelry that's in Ms. McIver's estate, has now all of that been appraised?
There are a couple of items that I don't have current appraisals on that may be lesser value items, but I think that all the high value items have appraisals with them. A couple of the appraisals are old that may need to be redone.
Okay. Now, Ms. McIver's will lists out some specific cash bequests, but it also has a handwritten list that goes along with it, right?
Yes.
What's that list called? It has a name, doesn't it?
Precatory list of gifts that she has handwritten that she wished to make to individuals, where the executor is requested to do that but not mandated to do it.
Okay. And that precatory list on states 441, I'm going to show the last 2 pages. Is this the same list, the precatory list?
Yes.
Okay. And you have a copy of this list, right?
I do, yes.
Have you taken any steps to do anything with regards to this precatory list?
Just recently drafted a letter to these individuals and contacted them by phone. My paralegals contacted them by phone to get an email address and told them that they are named. It is my intent to honor this handwritten list. I do believe this list is in the name of Diane McIver. It's my intent to honor it, and I've notified the people that they're going to be receiving a letter with a special request.
And have you gathered up the items that are listed on this precatory list?
Yes, I've gone through and double-checked to make sure that a description on this handwritten list is not as detailed as it could be, so I've gone through to make sure that I'm certain which watch, which Rolex watch, which Corum watch, which Cartier watch she's addressing.
Well, how did you do that? What steps did you take to make?
Well, it took some, just looking at the individual pieces and the photographs that were made and actual appraisals and matching as best I could.
Okay. And did you bring the jewelry with you today?
I did.
All right. Let me retrieve that. No, I don't think so. Okay. These items that I'm bringing to you, can you tell the jury just as a group, what are all these items?
Well, we have organized these in terms of the specific gift list, the precatory list, and they're separated out. And then there's another packet we've organized that are available for sale. And so we've separated those two collections.
All right, so let me start at the top of this list. Have you segregated out anything for Angie Brooks?
Yes.
All right, can you get that out so we can
Yes.
post it to the jury?
There are 3 items on Ms. McIver's list for Angie Brooks, and as you can see, we think that's Brooks, and I think we verified that that's her name. There's a ring, there are earrings, and there's a bracelet, all are ruby and diamonds.
All right. Describe for the record, what's the jewelry in? It's in a little clear plastic bag?
It's in a clear plastic bag, it's stapled to an envelope, and in the envelope is the appraisal. And for each of these items, these specific items, there is appraisals that were done previously by Mr. McIver and his staff.
Okay. So do you have 3 pieces of jewelry for Miss Brooks?
Yes, I do.
And is her name on the envelope?
They are.
All right. Do you have a pair of earrings?
Yes.
What's the appraised value for the earrings?
These are ruby and diamond earrings, and they are appraised at $11,000.
$11,000?
Yes.
How about the ruby and diamond ring? What is the appraisal value of that ring?
the ruby and diamond ring by the same appraisal company, and these are matching pieces, they're all rubies and diamonds, is $63,000.
$63,000?
$63,000.
How about for the ruby and diamond bracelet?
The ruby and diamond bracelet is $9,000.
Okay. May I have those items, please, Your Honor? I'd like to go show them to the jury.
Any objection to publishing them, Mr. Abate?
Is there a plan to tender them into evidence, or are they used for demonstrative purposes?
Just demonstrative purposes, I do not want to tender them as evidence.
I don't think Ms. Brooks wants to go in there.
I would prefer them not to.
Can we take a picture?
Can we look at it first?
Sure, why don't you take them to Mr. Abate, and then we can work on taking a picture, or...
While they're looking at that,
I'm going to ask a question first, if that's okay, because I'm a little confused. Were you involved with the estate in any way when there was an auction of Ms. McIver's jewelry?
No, sir.
So, are you familiar with how there's still jewelry around, and yet there was this auction of these items that weren't sold, or weren't, if you know, and maybe people were going to get there, but I'm having trouble keeping up with this based on...
I'm not really certain. I believe, though, that there were some items that individuals may have wanted to purchase. There was some decision made that perhaps this item would be sold to a special person who requested. It could be that some of the items were placed for auction. I'm not certain of every...
Yeah, I don't want you to speculate.
Okay.
So you are post-auction, and when you got involved, there was this jewelry here.
Yes, sir.
well, how about this question? Who gave you the jewelry?
The lady who was doing most of the day-to-day work for Mr. McIver, Tammy Johnson, physically brought all this to me.
At the time she brought it to you, how did she present it to you? Was it segregated in any way?
I did some reorganization that made it more precise, but she did do a general segregation of these are the precatory items and these are the items that are not specifically bequested. And we had various conversations about what might go with this and might go with that and what the thoughts were, but I'm not, don't have any personal knowledge about all of that.
All right.
Can Ms. Clark-Palmer have...
Or I could ask a few more questions.
Okay, no, that's fine.
I think we should take pictures.
So we're clear on the record, the plan will be for, it looks like both sides to use their digital cameras, their phones, to take pictures of these items that are being published but not tendered. And we may, later outside the presence of the jury, to not take up the time, figure out if we want to make those photos part of the record. Great, let's do that.
All right, thank you, Your Honor. And I'm going to publish these to the jury and pass them down if you want to.
You're keeping track of how much
I'm watching.
$60,000 jewelry you push into the jury box. Well, now it's coming back out. Right.
60 plus 11 plus 9.
I'm not going to do this with all the jewelry on this list,
Good.
just these items, and a couple more. And while we're looking at that, do you know if Ms. Brooks has been contacted yet about her items?
She has been contacted at least to the point of getting an email address for her. I didn't personally talk with her.
Okay.
So if you're going to share more items, which you're free to do, let's do them all at once.
Okay.
This is taking a little bit of time.
I don't intend to publish any of the other items in this manner.
Okay.
All right.
Get 3 full envelopes back.
Yes, I did. All right. Do you also have Diane McIver's wedding ring
Yes, I do.
with you?
Yes, I do.
All right. And are those the wedding rings that are left for Mr. McIver in the will?
I believe so, yes.
Okay. And do we have a appraisal for those items?
Yes.
What's the value?
There is a solitaire 4-carat diamond ring valued at $21,485. There is 2 wedding bands that are valued at $2,500 each. And then I believe they evaluate the prong, the setting of the solitaire diamond separately, and that's valued at $1,800.
All right, thank you. Do you also, so without going through each item on this list, do you have an envelope that matches up with all the names on this list and their corresponding item of jewelry?
I do.
All right. And the second page, what does it list? I mean, it shows some names on there. What do these people get to do with regards to the jewelry?
This is something I don't recommend that people do in their wills. The second list is you may choose from the following. These individuals may choose from the following, but choose from what is a little bit unclear, and I have been talking with, trying to figure out exactly how to manage that.
Okay.
I haven't made a final decision whether these individuals, because obviously much of the jewelry was sold and is not available anymore. So I haven't made a final decision how to address all of the other pieces the following people get to choose.
You also have a silver bracelet with you.
I do.
May I have that item, please? I'm sorry, does the silver bracelet have an appraised value?
It does.
What's the appraised value?
$5,000.
5,000?
Yes.
All right, may I have that bracelet, please?
Yeah.
And I'll put this one up on the overhead. And then I will put it back in the bag and let the state take a picture. For the record, can you describe this bracelet? Just like what color type of metal is it?
You have my appraisal. I don't know if it's white gold or silver, but it's a diamond bracelet.
Okay.
It is a white gold bangle cuff style bracelet.
Okay. And it's got some small diamonds set in it.
93 is what the appraisal says, with a total carat weight of 2.75.
And I'm going to put states 419 up. With this bracelet next to it. Do you know if this is the same bracelet?
I believe it is the same bracelet.
All right. Okay. And on states 401, all right, you see where it says white gold, ruby, and diamond earrings? Okay. Can you read for us where it says it's property from? Can you read that? Can you see it?
Promised property from the estate of Mrs. Diane Smith McIver, Atlanta, Georgia, $1,800 to $2,400.
And what was the appraised value of the ruby and diamond earrings that you have set aside for Miss Angie Brooks?
Those are, the earrings were $11,000, I believe you have them, and the bracelet was $9,000.
And then the ring was 60-something thousand?
$63,000.
All right. Those are all my questions.
Okay. David, Mr. Abate, question for the witness? Yes. Watch you do it.
There's some there.
We're going to finish. I know you won't leave without it.
It's been noticed.
Good afternoon, Ms. Margaret, Ms. Holloway. How are you
Good
today?
afternoon, fine.
Give me 1 second. Now, I believe Miss Clark Palmer just, she just showed you the earrings, the ruby and diamond earrings. Is that correct?
We've talked about the earrings, ruby and diamond earrings that are in my possession that I believe are the precatory list, and then she showed me a picture of different ruby and diamond earrings in the book.
So on page 192 of State's Exhibit 401, those are also ruby and diamond earrings, correct?
Yes.
And the list that was attached to Miss McIver's will said ruby and diamond earrings
Yes.
as well, correct?
Yes.
And if Miss I'll ask a better question. The range 1,800 to 2,400, do you know where that price range came from?
No, I don't.
And does that price range that's used at the auction, or in this auction, is it the same, or does it have to be the same as the appraisal value?
Well, there are two different rings, as you know. I mean, two different earrings. So I don't have any familiarity with the rings that are in the auction book, the earrings that are in the auction book.
And is it possible that when you are quickly trying to sell someone's items, you discount them so they sell quicker?
Selling jewelry is hard to do from the States. I've done it before, even nice jewelry. It's very hard to do, and discounts are frequently appropriate.
Okay. So it's possible that those earrings in that book are worth more than $2,400, correct?
In that book, I don't have any opinion about the appraisal on that book.
Okay. But they could be worth more than the, I guess the number value, the dollar value range in this book, correct?
I could speculate that they could be, but I don't know.
And the appraisal, I guess, sheets or values of 3 items, a couple of the items that Ms. Clark Palmer showed you. You didn't do those appraisals, correct?
No, they were done by a professional appraisal company. I did not hire that company.
Okay, and they were done prior to your, I guess, involvement with the estate of Ms. Diane Madden, correct?
Yes, sir.
And did you get all of the appraisal sheets that you were looking at, did you get all of them from, I guess, Mr. McIver or any of his, I guess you said staff, any of his staff?
Yes, I did.
Okay, I'm going to show you.
You're talking about the jewelry that's in my possession all came with, most came with appraisals. I think that's what you're saying.
Okay, I'm going to show you this and see if you received this appraisal sheet.
And may I see it after she looks at it?
Yes, I'm sorry.
That's okay.
I really don't remember seeing this appraisal sheet.
Okay. Now, I guess, when did you, and you probably said it under, and I apologize if I was distracted, but when did you exactly get involved with working with the estate of Mrs. McIver? When were you, I guess, hired?
I was appointed by the court July 19th, 2017. I was having conversations. I was called by Kirk Watkins, a high school friend of mine, sometime in the spring last year, and we had some initial preliminary, very not significant conversations, and then it became more detailed about my experience and was I possibly interested in serving to succeed Mr. McIver as successor administrator.
And you said those conversations, I guess, prior to your appointment, you said was it in the spring, is that what you said?
I think it was about April, May-ish of 17.
And you said it was with Kirk Watkins, correct?
And then I met Stan Smith.
Okay. And I guess, how are they, what was their involvement with, I guess, the estate of Diane McIver?
They were the counsel for the estate.
Okay, so you began having conversations with the counsel for the estate well before, it sounds like, your appointment, correct?
Yes, there was a procedure for me to be appointed. There had to be a petition. There was a set of pleadings that were filed in the probate court about Mr. McIver's status, and I believe ultimately it was his petition to resign based on issues that were being raised about his ability to serve.
Okay. And you said that they were, I guess, so there were pleadings filed, correct?
in the probate court.
Okay, and did those pleadings have anything to do with Mr. McIver being the executor of Mrs. McIver's will?
Yes, the pleadings in the probate court, this is the procedure that's required when one administrator takes over for another, is that the court is in charge of that decision, and there's a process where a petition is filed. And I think the actual petition that was filed was Mr. McIver filed to resign. And then there was a consent order between your office and counsel for the estate that I be appointed. And Judge Pinky Toomer chose to enter that order based on the consent of the parties.
And who was advising Mr. McIver as to that issue?
I believe Mr. Watkins and Mr. Smith were advising him about his status as executor, whether or not he could continue to serve based on the conflict with your office and the charges.
And advising, they were, to your knowledge, were they advising him about his ability to be the executor of Mrs. McIver's estate?
I guess I'm going to object, Your Honor. I'm not sure how she would know otherwise.
I'll rephrase the question. I apologize.
We gotta make sure we don't get into privilege areas,
Of course. The pleadings that you are referencing, those pleadings were about Mr. McIver being the executor of Mrs. McIver's estate.
Well, there are initial pleadings in the probate court appointing him based on the will's direction that he be named the executor. And then the pleadings where I succeeded him, I believe are styled as his petition to resign.
Okay. And when was Mrs. McIver's will probated?
I don't have the exact date in my mind. I wasn't involved in that, but it was in early October, I believe, 2016.
Okay. Would October 11th of 2016 sound correct?
Yes, sir.
Okay. And from October 11th of 2016 until when did Mr. McIver resign from being the executor?
The court order was July 19th, 2017, appointing me. There was another procedure, I believe, where his status changed, where he went from executor to temporary administrator, which limits his authority. I believe there were some preliminary procedures that your office was involved in the probate court through counsel that your office hired, if I'm correct.
Now, so from October 11th of 2016 up until July 19th of 2017, isn't it true or correct that Mr. McIver controlled or had part control of all of the assets of Mrs. McIver?
He had total control until the time, and I can't be exact about the date of this, but based on the litigation between your office and the estate, he was, I think the most accurate way is he was demoted. He could no longer distribute property after being named temporary administrator. He could only collect it. I believe I'm correct on that, and the court record will be more precise.
Okay. And is Mr. McIver, is he also a beneficiary in Diane McIver's will?
Yes.
And is it common for the executor to also be a beneficiary?
It is common. It's certainly not uncommon.
Okay. And does that create a conflict?
It creates a conflict in some instances. In this instance, I believe there was a conflict. It doesn't always set forth a conflict.
And is that conflict the reason for the litigation of, I guess, involving Mr. McIver being the executor?
Yeah, your office could speak more thoroughly about your raising that issue in the probate court, but I believe that conflict was part of the pleadings before the probate court.
Okay. And you said, and I apologize, I know you've told me before, how long have you been, I guess, managing or dealing with estates?
I have been the county administrator on appointment of various cases for at least 25 years. I'm not actively on the list today. I'm still managing estates that the court has previously assigned to me and in conservatorships.
And based on your 25 years of experience and what you know about, I guess, the issues and circumstances surrounding Mrs. McIver's death and the probate of her will, excuse me, for not probation, the probate of Mrs. McIver's, I guess, estate, do you agree that that was a conflict?
Objection to the relevance of her opinion about the conflict, based on the way Mr. Abati phrased the question.
Okay, I'll rephrase the question.
That's a good idea.
In your 25 years of experience, have you dealt with probating estates where the individual who has died, the person who caused it was their spouse?
I have dealt with estates where there's been a spouse, where there's been a girlfriend or a boyfriend or a sibling. I have dealt with estates where allegations of bad behavior, either criminal or negligence or civil, have been part of the conflicts that arise among the families or as a matter of law.
And in those situations, if the person who caused the death of the individual, if they are both the executor and the beneficiary, would you consider that to be a conflict?
I do consider that to be a conflict.
And is that the same or similar situation that is occurring with the defendant and him being the beneficiary and the executor of Tex McIver's estate?
I believe that is a conflict in this case.
Just to go back to the appraisal receipts that you received for some, if not all, of the jewelry that you have in your possession, when were those appraisals done?
They have dates on them, so if I think y'all still have my appraisals for the ruby and diamond matters, but the wedding ring appraisals was November 2016. November 8th, 2016.
And the three items that Ms. Palmer showed you, when were they appraised?
See if they were all the same date. The earrings were, the date of the signature of the appraisal was November 11th, 2016. The date of the appraisal for the diamond and ruby ring was November 11th, 2016. And the bracelet, ruby and diamond bracelet, was also November 11th, 2016.
Okay. That was great if we didn't need to make Ms. Oliver come back tomorrow, but we do need to end in a little bit. So,
I will definitely do my best.
okay.
The appraisals, you said they all, of what you had, they were all in November, correct?
The ones I've just looked at were all in November, the wedding rings and the ruby and diamond 3 pieces.
So all of the items, the jewelry pieces that you looked at, have you looked at the other appraisals for all the jewelry that you have?
I've looked at them, I haven't memorized the dates in all of them.
Do you have a document that would refresh your recollection as to each appraisal?
I think I would really have to look at each of them individually, the way I've organized
I'm
them.
not really sure how to do that. But the items that you just looked at and talked about, if those were appraised in November of 2016, that would be before the estate sale that occurred in December of 2016, correct?
Yes, sir.
And that would also be before the auction that occurred in January of 2017,
Yes.
correct?
Yes, sir.
And you said that your involvement was well after both of those events, correct?
Yes.
So you have no knowledge as to whether those items were left over or items that were not sold from the auction or the estate sales, correct?
I have no knowledge.
Okay.
I have no knowledge.
And Ms. Clark Palmer showed you the envelopes, specifically the ones with the name Angie and then was it Brooks that's written on them? Okay.
The first name that was handwritten, and I believe that was my handwriting, was Banks, and then Brooks was added to it. If you look at the handwritten note, it's probably true that I read it as Banks, or she may have had a different name.
Okay.
This handwritten document is from 2006, so it's old.
Okay, thank you. the item, or I guess the labeling of the names, did you do that?
I believe that Tammy Johnson did the first name, and I was the one that was double checking to put the last name together with the specific item when I was double checking the organization of what was a precatory gift to an individual.
Okay. And I believe you said that Miss Brooks had been contacted?
I believe she, as my paralegal, has contacted all of the folks that have been given a suggested gift and asked for their email. I'm not sure how much, I don't know if they were told exactly what they were getting, but that they would be contacted by me.
Do you have knowledge of when Ms. Brooks would have been contacted about those alleged items that would go to her?
Within the last 2 weeks, about.
So she would have been contacted during this trial, correct?
Yes.
Now, let's talk a little bit about,
Were you directed to try to contact folks who were going to get jewelry from the estate during the trial, or it's just a coincidence and it's the course of the work you've been doing that happens to overlap when some of these same people would be coming in to testify?
It's a coincidence, Your Honor, because I was waiting for the session. General Assembly was in it to get back to real work, and so it's purely coincidental.
okay.
I don't know who Ms. Brooks is. I don't know her role in this trial,
Okay.
if she has a role in this trial.
Now, just to talk a little bit about, I guess, how estates are probated. When you took over, I guess, as the executor, did Mrs. McIver's estate have any big liabilities?
I always consider taxes as a big liability.
Okay. How much in taxes did Mrs. McIver's estate owe?
Well, there were multiple tax returns that were owed for 2015, 16, and so I don't like to guess and remember, but it was almost all of it together over $100,000 in that range.
Okay.
Between $80,000 and $100,000 that were owed for pieces of those tax returns that had to be filed.
Any other large expenses, or I guess liabilities, or debts, I guess is a better word?
Attorney fees and real estate taxes. The estate still owned the real property, so we were paying property taxes on all the properties up until the sales debt. There were attorney fees, there were accounting fees. There were smaller fees, for instance, that kind of had ongoing HOA expenses. There were upkeep expenses at other properties.
And when you talk about expenses, did you review all the checks that were written prior to your becoming the executive?
Yes.
And in those checks, were there checks made out to the rental plantation golf courses?
I believe there were, if I'm remembering correctly.
And is that a state expense?
It was, this is my memory of that. The ownership of the lot gave Mrs. McIver a membership that was really available to both parties. I think it was a monthly fee of maybe, I don't want to try to remember, but it was an obligation that she had since the membership was in her name, whether or not it should continue. I did not pay after I became involved, but initially I believe it was a debt of the estate.
You said you didn't pay it?
I didn't pay it.
Why did you not pay it?
I'm more than a little bit conservative about paying debts, and I'm just not 100% sure of it. I just think they can wait on their money. They're certainly not a priority claimant, and what happens to the membership, what happens to the lot, is just a little bit not known yet. I wasn't sure, I'm remembering now, if you want me to remember, I believe the membership may have been transferred into Mr. McIver's name. Somebody's telling me, I'm remembering that, and he may have picked it up at some point. I can't be certain as to what dates that happened.
And if those were paid, I guess, after Mrs. McIver's death, or what was the reason? Let me ask a better question. The payment of those fees to rental plantation allowed either Mr. McIver or Mrs. McIver, who couldn't play golf during the months after her death, correct?
I believe that would, I don't remember exactly the status of the membership. I think it was both of them are members, I'm just not sure. But I assume, if you'd like me to assume.
No, you don't. And I believe Ms. Clark Palmer, she showed you State Exhibit 419. I'm going to direct your attention to, do you see the ring? The diamond next to the
I see
ring?
something that looks like a pendant,
Right there.
Well, I'm not 100% sure that's a ring, but I see what you're pointing at.
Let me show you page 182 of State Exhibit 410, or excuse me, 401. Does that look similar to the item of jewelry in the State Exhibit?
Yes, it looks like it's similar.
Okay. And do you know where you know what items of jewelry they are in the State Exhibit?
I know what I've been told. I've been told.
Don't tell me what you've been told, but who told you?
I don't remember whether it was Tammy Johnson directly or Tammy Johnson through my paralegal. I don't remember how many steps it took.
And is Tammy Johnson, is she a member of Mr. McIver's staff?
She was hired to assist him while he served, yes.
Assist him or assist the estate? Or both?
It changed. I believe that she was doing estate work for him, working for the estate, paid by the estate, and then when I assumed responsibility, I think she has been continued to be paid by him to help him with other matters.
Okay. Now, the sale of the condo, how much did it sell for?
$604,000.
And from the proceeds of the sale, you talked a little bit about the fact that Mr. McIver had to, I guess, allow the sale?
He had to allow it because he had a real property interest in the estate as a life estate. So I didn't have full title to the property. I wasn't authorized fully to sign it without his agreement.
And you said he had a real property interest. Does that mean that he gets money from the sale of the condo?
No, I have to, we being me and counsel representing Mr. McIver in relation to civil matters and estate matters, have had a number of conversations about evaluating the dollar value of his life estate. This is fairly common. I've done that in other states before. Mr. McIver was willing to release his interest that may come to him in the life estate of the condo in exchange for the debt he owes the estate. And we had discussions about that. We had negotiations about the dollar value of the life estate and the note that he owed the estate of $350,000.
Okay. And if Mr. McIver didn't owe a note, would he get a cash sum for the life estate that he had in condos?
His life estate has a dollar value, and we have not agreed to date on the dollar value of that life estate. So if I had sold the condominium, he would have had to agree to a dollar amount, I think, or as we did, we didn't reach an agreement but chose to set aside a certain amount of money for later negotiations.
And I guess you said there hasn't been an agreement. What is your opinion as to what Mr. McIver's dollar amount of his life estate is?
Mr. McIver's counsel, Mr. Rothschild, and I have exchanged a number of different emails on that dollar value. My value, and we're quite far apart, my value was about $190,000, and Mr. McIver's counsel's estimate was more in the range, I believe, of about $300,000. So we were far apart on that.
So whether it be like $190,000, almost $200,000, or $300,000, Mr. McIver wouldn't be getting that sum of money had his wife not been shot and killed, correct?
Well, he had he may have two benefits of the will, again, depending on various future decisions. And his value was either his ability to live in the condominium, which would have been a benefit, a life estate, or if he chose to negotiate a cash amount that represented his opportunity to live there.
But he didn't have those options unless Mrs. McIver passed, correct?
That's correct.
Okay. And how much is your fee?
The negotiated fee is $10,000 a month for the first 6 months, and then an hourly rate based on matters that may go above that. That's in the probate court pleadings, I believe.
Okay. And the $350,000 loan that Mr. McIver owes, how much principal has he paid up to today?
I believe it's $1,300 a month, and he's paid every month that I've been involved.
How much principal has
Oh, wait, I'm sorry, excuse me. He has not paid any principal. The note was due December 1st, and he has not paid principal.
Okay. And it was due when?
December 1st, I believe.
So, and that was prior to your involvement with the estate, correct?
No, it was after. It was December 1st, 2017.
My apologies. And so on December 1st of 2017, he was actually in default, correct?
Yes.
And since he was in default starting in December of 2017, could the estate then have foreclosed on the ranch?
It's possible, yes.
And who was the estate being controlled by at that time?
Me.
I'm talking about in December
Oh.
of 2017.
It was controlled by me in December 2017, and December 2016, which I don't believe the note was due yet,
Right.
it was controlled by Mr. McIver.
And prior to your involvement do you know if the payments were being made timely?
I don't know exactly timely, but I believe they were being made.
And is it appropriate based on your, or is it common based on your, I guess, experience for the last 25 years in doing this, that the executor pays his personal American Express bill with the state funds?
Well, objection to assuming facts that are not in the record.
Your Honor, the statement generally has been marked as 526 as the business record, the business record exception.
So my thought is, because I kept the jurors 10 minutes more than they said they could stay anyway, because I'm gonna let them go. We'll need to bring Ms. Oliver back in the morning. You guys can work through this, but we still have redirect, and I don't want to cut you short. So, ladies and gentlemen, before you go, I count 3 potential witnesses remaining. You need to work through something, but apart from recalling someone, at most it's 3-ish witnesses left for the defense. Is that a fair statement? Just so the jurors can get a sense of scope. Okay. Ladies and gentlemen, have a super Thursday evening. Tomorrow will be Friday. Look forward to seeing you Friday morning. We will do our best to get started as close to 9 a.m. as possible. We can't do it without all 15 of you. You'll go with Deputy Murphy. I'll see you in the morning. Have a great evening. We'll talk about the case. No outside research. All rise for the jurors. Does Miss Oliver need to bring all the jewelry back? I suspect that's a complicated endeavor. Can it go to wherever it is being kept safely and stay there?
I think what we discussed outside the court's presence and the jury's presence is that before she leaves, I think we want to have the opportunity to take a couple of pictures.
Yes.
And so if we could just do that, is that okay? Then we would do that, and I don't think we would require her to come back.
Okay, Ms. Oliver needs to be back.
Right,
I think tomorrow,
the jury.
but the stuff that came in the Brinks truck can stay outside the court.
Right.
While we lower everyone's pulse rate. Great. Thank you, Ms. Oliver. I don't know that the jewelry can leave quite yet, but you were able to get up and move about freely. defense, for planning purposes, we'll wrap up Ms. Oliver's testimony, I suspect, pretty early on tomorrow morning. I've been surprised by lots of things. But we have some pretty serious weight-bearing witnesses remaining that won't fly by. Do you know yet, Mr. Harvey, just inquiring, not questioning, whether you have two forensic folks or holistic or reconstruction folks, or it really depends how the first one goes? Is that the structure of it?
Yeah.
Okay.
And I told you yesterday, and I'll repeat today, and I told Mr. Robert that I'm going to endeavor not to be repetitive, just like the witnesses say the same.
I appreciate that. I think that you all get where the jury is now. But there are witnesses who are talking about something important. And so you'll strike the balance that you think is appropriate for the work you're trying to do. But as I understand it, you call Mr. Gardner, and depending on how that goes, then you call Mr. Robinson, or is it backwards?
No.
Okay. Okay. And we still have Mr. Culver. And you're going to work through Mr. Samuel, whether you're recalling someone. Okay, I take you at your word when you block these things at me. All right, just dump me this time.
And the jury.
We do have that. We have a potential rebuttal case, so.
I said, don't say it out loud.
I thought you said don't forget to remind them about the jury.
Okay. No, I haven't forgotten about that.
Forget if I said that.
I will forget that, but I haven't forgotten about the jury view. Just for planning purposes then, it's entirely possible that we don't finish your case tomorrow, and so we get into next week. And then we'll see what remains of the state's case. If you are going to have rebuttal witnesses, and you may have folks in court during testimony tomorrow, the way we discussed, because experts get to be here for opposing experts. Maybe we'll have a better sense at lunch whether late tomorrow we might possibly pivot back to a state presentation. But
short presentation. I'm expecting,
okay,
but we'll see after tomorrow.
Okay, but the other thing we could do if it's 3:30, I don't think we're going to get to this point, but if it's 3:30 and the defense says we don't have anything else, we have a charge conference we could work with, so we're going to be sending jurors home. Mr. McIver and I need to have a conversation on the record. It sounds like we're getting close to needing to have that conversation. Maybe at lunch tomorrow I should bring it up again and we'll be at those crossroads.
We may rest before lunch.
Okay, that would be record time for Mr. Culver.
It's not probable.
Okay.
Possible.
Okay. All right.
Like this. I've seen that.
I'll just make a note of it, and we'll make sure we have that conversation before we hit those crossroads. So, Mr. McIver, I know you've been thinking about it and conferring with folks, but it sounds like at some point tomorrow, on the record, outside the presence of the jury, you and I will need to talk about your decision to testify or not. And you're right to do so, you're right not to do so, and the protections you enjoy in one direction and what you'd be exposed to in the other direction. We'll get all that on the record. But I'm sharing this with you now because what won't work real well is if we reach that point and you say, Judge, actually I need more time to think about it. So continue thinking about it. We're not there yet. Just know that it sounds like soon, probably tomorrow, possibly tomorrow, we'll need to have that discussion. Okay? Great. Anything from the state? Okay. Then I'll see everyone around 9 o'clock tomorrow for planning purposes. The schedule says that I have to be on a conference call at 1 with a county commissioner. So we'll break a little before 1 at the latest. We might break earlier than that, but I just got to wrap up. It won't be a very long call, but that's the one marker I've got tomorrow. Okay. Thank you, everyone.
Thank you.
Okay.